What should I leave out of my estate plan in Georgia? Hi, I'm Zach Beck, an estate planning and probate attorney with Peach State Wills and Trust, a division of the Beck Law Firm LLC, here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, what should you leave out of your estate plan in Georgia? When we get this question, it's often from clients who are thinking of leaving out a particular asset or group of assets from their estate plan, and instead are planning to just leave oral or written instructions to their heirs and beneficiaries as to what they want done with those particular assets. However, there's not much that we want you to leave out of your plan. We want your loved ones to know what your wishes are in regards to your property and how you want to be treated healthcare-wise if you can't speak for yourself, and we want those wishes to be in your documents so that they have to be followed. However, there are a few things that we are okay with and recommend leaving out of your plan. We don't want to get too specific in your will or your trust with the descriptions of property. For example, if you intend to leave someone the funds in your checking and savings account, which, let's hypothetically say, are at Bank of America, we want the description in the plan to say, the funds in my checking and savings account should go to X, rather than the funds in my Bank of America savings account ending in 1234 go to X. That way, if you were to switch banks or otherwise move money around between accounts, the gift that you intend to make is still valid. If you only list the bank account with its exact number, and you no longer have that account when you pass, that gift lapses entirely and the funds won't end up going to their intended beneficiary. Further, we don't need to include every single item of tangible personal property that you own in your will. We don't need to say who the expo marker or the candy bowl goes to. In Georgia, we can include what's known as a personal property memo clause, which allows you to later decide on the distribution for certain items of tangible personal property, list who you want those to go to in a separate signed memorandum, which is then incorporated into your will by reference. Moreover, we don't even need to list every single item of tangible personal property in the memo. While the memo is useful for valuable, both monetarily and sentimental items, it's impractical and almost impossible to list every single item of tangible personal property that you own in the memo. And moreover, it's really unlikely that your beneficiaries are going to argue over who should get the file cabinet, the expo marker, or the pencils. While we want your beneficiaries to know where you want the valuable items to go, it's unnecessary to plan for every single item in your house. Your beneficiaries will often agree as to the distribution of a lot of those items, and more often than not, it may be that most of those items get donated or sold. For more information about estate planning, download our free guide to estate planning on our website at peachstatewills.com or give us a call at 678-344-5342.